you would be knowing a lot of things related to intellectual property law and intellectual property as a subject. However, we are going to today travel through or traverse through a domain which is not much heard of, but at the same time forms one of the biggest areas of litigation in the world today, and that is patent drafting. But to take you to this complex subject of patent drafting, I would have to once again revisit. You have already been into a workshop for the last 2 days. Uh, Somebody was requesting control. I have given that control. So going back to what I'm saying, you have already been listening to a lot of discussions on intellectual property, and it's my part of my responsibilities today to take you through a little bit of the basics, just to put so that you can put things in perspective when I discuss the main subject of patent drafting. Unfortunately, the video is not on, but I would like all of you to close your eyes and for 1 minute bring back to memory something. Bring back to memory something that we have all played with, and I'm sure all of you can recall a Rubik's Cube. Can you all recall a Rubik's Cube?
Yes, ma'am.
Do you know what it is? What would you call it? What would you call it?
It is a cube.
It is a cube. Only that? Only that? You would call it only a cube?
A puzzle with cube. Different colors.
Different colors puzzle. Okay. Can you give me a better word for a puzzle?
Creativity.
Sorry?
Challenge.
Creativity.
I'm not getting it. I think two people spoke at the same time. Yes?
Challenge.
Creativity
Challenge.
is there, huh?
Challenge, yes.
Creativity is there.
Creativity. What kind of creativity? Great. Come on.
Yeah, it's a cube. You know, if you are going to add up the opposite numbers on the cube, it always comes out to be 7. So something creative is there.
Something creative is there, but is that the most creative element of the Rubik's Cube? Can anyone tell me what it is?
All the elements are movable.
Yes, that is the most important element of a Rubik's Cube, that all parts were components of the, I won't say all parts, the components of the Rubik's Cube was dynamic and movable. Any other thing that comes to mind? Which kind of segment would you classify Rubik's Cube into? Would you call it a toy? Would you call it a game? Would you call it a puzzle? Or would you call it something even more important than all of this?
Ma'am, Rubik's Cube comes in a category of toy and as well as a
Comes in
puzzle.
the category of, sorry, please speak loudly.
Category of toy and
Category
puzzle
of,
both.
not getting it.
Toy. Category of toy.
I'm not getting it.
Ma'am, category of toy.
Coil.
Toy. T-O-Y.
Toy. Category of toy. Yes, okay. Anything bigger than a toy that you can think of giving a name for it?
A solver, madam.
No.
Because people use some formulas to solve it and do it at the same time, and they even create records doing it. So it's almost a solver.
So you're saying like a mathematical formula.
Exactly.
But there
It's
are
a solver.
so many, there are more than 43 quintillion ways to solve the Rubik's Cube. That's not a joke. 43 quintillion ways to solve the Rubik's Cube. So it's not one formula. It's like so many that were there. I'm going to start showing you bits and parts of the Rubik's Cube here, and to give you an idea, and then I will tell you in the end what Rubik's Cube will be called. All right? To me, it was a revolution. We only looked at it like a toy. All of us looked at it like a toy. For us, it was amusement. For us, it was entertainment. But you have to see the science and technology that went behind the creation of Rubik's Cube. Like somebody said, there was a lot of creativity involved in the Rubik's Cube. True. The creativity in the Rubik's Cube was mind-boggling. Why? Because just when you look at it, it looks static. But when you think about it and you put it in your hands, you realize that it's dynamic. Straightforward picture of the Rubik Cube looks very simple until and unless you start working on it and then you realize, oh my God, it's so complex. We have to match and get all the colors uniform way. So there was this bewildering contrast in the Rubik's Cube. So many contrasts in the Rubik's Cube. Simplicity versus complexity, stability or staticness versus dynamism, order versus chaos. All these were the complexities with the cube. And mind you, this mind-boggling piece of puzzle, as we used to call it, was created by only a 29-year-old Hungarian. Erno Rubik was basically an artist, was a sculptor, and he was a lecturer wanting to teach his students how the moving parts of a different object looking in a static way will appear. So he was trying to solve what is called as structural problems of moving parts. This was his main objective in creating. He says, how do I show it to my class? That's the whole genesis of the Rubik's Cube. So at the age of 29 years, he invented this Rubik's Cube in 1974 to help his students understand 3D objects. All right. Now I come to something else. I'm telling you that in 1975, he applied for a patent and he was granted a patent in that same year. But somewhere later, within 5 years, he licensed that patent. I hope whatever terms I'm using to you now sound familiar from the last 2 days that you are engaging in these intellectual property classes that are going on. So in 1980, he licensed the patent to a company which was called then as Ideal Toys Corporation Company. So it is a company, but when you read the name Ideal Toys, it tells you very clearly that these people were the manufacturers, retailers, distributors of toys. It was centered in Europe, but obviously they would be having presence all over Europe and of course in some other parts of the world. Once it was licensed, they realized that this toy was not selling in its original name, but it famously came to be called as Rubik's Cube. Rubik's Cube is also a trademark. So that was taken as a trademark in years later when they realized the potential of the intellectual property in the brand name Rubik's Cube. Interestingly, for all of you to note, between 1980 and 1983, 200 million, I repeat again, 200 million Rubik's Cubes are sold in just 3 years. And subsequently, over 350 million Rubik's Cube was sold worldwide. Of course, it went on to spawn various international challenges, tournaments, just like you have chess competitions. There were Rubik's Cube competitions in the world. World Cube Association was formed, so on and so forth. A movie was made in which it formed a central theme, and that was Will Smith's Pursuit of Happiness. And ultimately, Erno Rubik became one of the richest millionaires in Hungary. All right. It's something to be said that this has been the world's largest selling toy to date, the Rubik's Cube. So I come back to my original question. What is the Rubik's Cube?
Innovation.
It is a scoring tool.
Okay, someone said innovation, someone said scoring tool. Any other inputs?
A tool for testing the intellectual capability of a person.
So when you call it a tool for testing the intellectual capability of person, is there no shorter word to describe it?
Somebody's idea to explain the things.
Benchmarking?
No.
Is it benchmarking?
No, not benchmarking.
Assessment tool?
It's not a landmark.
All right. You know, someone began by saying it's an innovation. I would take that path and I would go a step further to say that it has been one of the most revolutionary inventions in the world. The word is invention. It may be a toy, it may be a puzzle, it may be a challenge, you may choose to call it whatever. But ultimately, at the core of it, it remains a beautiful invention, a great invention which has stood the test of time. There's also another lesson in this. The lesson in this is also to tell you that we must realize how entertainment is fundamental to human nature and how entertainment is big business. I mean, we would not have had Hollywoods and Bollywoods in the world today if entertainment was not a big business. And the entertainment sector, the media and the entertainment sector is riding completely on mind-boggling innovations and inventions. All of them are there in the entertainment sector. So if there were no great inventions, the world would have not been what it is and what we are witnessing today. Simple situation, we are all in the midst of a pandemic, 2 years gone by, but we have all managed to communicate with one another, you know, just like I'm doing just now, or, you know, others are doing. Life is going on with the help of technology and, you know, connecting over Zoom or Teams or whatever you choose as a platform to do so. So this is the beautiful aspect of technology. I'm taking you next to a slide which talks about the greatest innovations of all time. This first slide, this first part of it is basically all inventions. Inventions that have changed the world. And then there were innovations on these inventions to make it what it, for example, one of the greatest invention, the world communication invention we all know today is a telephone. But look where the telephone has been innovated, and today we have different class of, you know, cell phones that we are all using and are completely dependent on. So there were innovations. You have all these innovations. I hope you can read them. Then we have top innovations of all time, which is the internet, computer, light bulb, compass, semiconductors, written language, wheel and axle. Then we also have great design thinking examples, which are again ruling the world today, for an Airbnb, a clean pack, a clean team, a pill pack, whatever. Different hospitals are coming out in terms of services that they are offering to their people, just like Stanford has done. Similarly, Uber Eats, and today, Uber Eats is very popular in the Western world, while in India we have Swiggy and Zomato, which has changed our lifestyles completely. One of the great innovations or design thinking examples that I like to talk about is Sulabh Sauchalay, but I'm just leaving the thought with you and I won't dwell on it and go on to the next slide. So coming to, therefore, what is intellectual property? Fundamentally, at the very basic level, it's an idea, but an innovative idea. All ideas do not have value in it. There are certain ideas that we find great value in it. And why do we find great value in a certain idea? We find great value in a certain idea because that idea has been, let me put it this way, the idea seems capable of propagation. The idea seems capable of distribution. The idea keeps capable or seems capable of selling. selling forms a core component of a valuable idea. You know, जैसे हिंदी में हम कहेंगे जिस आइडिया का कोई दाम नहीं है, that idea has no value. So we should be able to price the idea and take it to the next level, which means we should be able to sell the idea. So such ideas which have value in them, which have an innovative aspect to them, they are the ideas behind technologies and inventions. So we say in law, any creation of the human mind that is locked in a tangible form, ultimately, golden rule, fundamental rule is this, that whatever is your idea, we should be able to translate that idea from the mind to the paper. We must be able to bring it to the drawing board. Until the idea gets translated on the drawing board, that idea will not have value. It will only remain an oral idea. Therefore, we have to get the idea to a tangible form so that the idea could be used, the idea could be propagated, the idea could be accessed, the idea could be distributed, and idea should be able to create a bundle of rights. So remember one thing, intellectual property is slightly different from intellectual property rights. So from the asset is born the set of rights that govern that particular assets. So intellectual properties have now been recognized as those vital, essential components of our daily life, which are very critical for us to govern whatever we are creating. So I've prepared this slide to show you the 5 fundamental intellectual properties, to tell you that this is not exhaustive. There are more intellectual properties which I will disclose to you in the next coming slide. And we will see how these form the most important intellectual properties. So what does patent do? This is something for all of you to remember always. Patents protect invention. So it may be technologies you're seeing in the marketplace, they are all protected by patents. What does copyrights do? Copyrights protect expressions, be it drawing, be it painting, be it architecture, be it a poetry, be it a film, be it a book, be it a novel, be it a story, everything is protected by a copyright. We come to the most commonly found intellectual property, and those are trademarks. Trademarks is very simply the trader's identity in the marketplace. So all traders are not known by their full long names. So for easier visibility, for easier recognition, people make some kind of symbols or use some kind of symbols or signs to find easier recognition in the marketplace. And those symbols and signs and whatever emblems, etc., that you have are known as trademarks. Finally, we come to designs. Designs are those very interesting intellectual properties without which companies like Mercedes-Benz and whatever all your famous car companies that we are talking about, a Volvo or a Beamer or they would never have been that without design. So what designs does is protect the outward form of intellectual property. One very interesting area of intellectual property is this one, which is GIs. GIs are known as geographical indications. Geographical indications are community rights, and they protect the intellectual properties of a community. So a community of producers. The producers could be in agriculture, the producers could be handicraft makers, the producers could be mining the earth to take out something from the earth naturally. All of this is possible in geographical indications. So people who are growing crops, India is famous for its basmati rice, its Alfonso mangoes, its Darjeeling tea, its Kolhapuri chappals. So all these belong to a region. So the rice is given to a region and the region propagates the technology in that produce and they will then get the benefits out of using that rice. Right? So these are the 5 critical intellectual properties that we are seeing today. We come now to more intellectual properties that are there. The 5 intellectual properties that we took are statutory rights. So there is a law for each of these of them. All right. Along with that, we have the Plant Varieties Act, we have the Semiconductors Act, and we have the Biodiversity Act. But what is not covered by laws or specific laws is covered under common law, that they are recognized. So there are unregistered trademarks, there are trade dress example, let me give you. For example, anybody who buys an Apple product would know that to go to an Apple showroom, everything would be in white. So that is a trade dress that Apple has adopted, the white and the logo. All right. So, for example, today, whoever is going to buy a Cadbury chocolate, you would see that the Cadbury chocolate has a purple color. This it is called as Fanta purple. Now, this the company Cadbury has adopted as its uniform color code to sell its products. So, this is a trade dress that has been adopted by the company. Then we have one big, large area of intellectual property, which is known as trade secrets. I'll come to trade secrets a little later. So confidential information and trade secrets fall in the same category. Technical know-how may fall in the category of trade secrets or maybe a know-how that you are sharing under contract. All right. Client lists. Generally, client lists are confidential information, but clients list, the clients that you have developed in a company are so important as intellectual property of that company. You alone know how you have got a client. You alone know how you are keeping a client. You alone know how you are servicing a client. So client list, people die. Competitors die to get the client list of the other companies. So that's one area of intellectual property. Systems of HR management, systems of raw materials, resources are all issues of intellectual property. Last but not the least, on which India has fought a few battles, and that is traditional knowledge. That knowledge, which is known for centuries and exists in the public domain and is coming from the region, it's coming from a particular area. For example, moment we use the word turmeric, then turmeric is something very specific to India. And not that only Indians are using turmeric, but we have analyzed and studied the uses of turmeric like no other country has done. So it's very common knowledge in India to know about the antiseptic properties of turmeric. Everybody knows it because it is there in the public domain. This is our traditional knowledge. Now, one important thing that I must mention about traditional knowledge is to tell you that traditional knowledge cannot be appropriated by a single individual or a single institution or by anybody that for that matter. Traditional knowledge belongs to the public. Public have rights on traditional knowledge and therefore you can use it for public good. But you cannot misappropriate it for your own good only. All right. We now come to the system of patenting, which is what I'll be talking about today. Want to mention one thing before I go forward. The topic says strategies in protecting intellectual property. Now, I just finished mentioning to you that all the intellectual properties are different, are varied, and the systems of protecting all of them are completely different. But when we look into the subject of claims drafting, we are specifically looking into the subject of patenting. And therefore, I'm going to talk to you now only on patenting. right? So given this, I'm talking to you, what is a patent? The word patent comes from the word letters patent. These were all the Roman Latin terminologies that were embraced by the British monarchy and the British systems, and therefore they were all sort of incorporated in the English language. So most of you would be knowing this, that the English language relies a lot on Latin roots, of words. The etymology is Latin, all right? Most of the time Latin or Greek. So here too, the word patent is from a Latin word. Patent means face. So the word letters patent means open letters or public notices. So what was really happening by the system of patent through the medieval times is that kings and monarchs were granting monopolies, were granting favors, were granting, benefits to certain favored people. So how would they grant it? They would grant it through a system of letters patent. So they would come to the town hall or come to the market square. They would gather people and read out from the public notice that the king or the monarch or the emperor has said, and say that so and so has been granted so and so benefit. That's how the system of patenting started. Today also, even when patents are granted, we still use the word letters patent. But what we are doing under the system of patenting is we are granting monopolies. Now, question is, who are we? The monarchs are all gone, except in few areas. Now we have governments. Now we have states. So the state is granting to a certain person a certain monopoly. Question arises, why should the state grant someone a monopoly? What is the great reason that it should grant this kind of monopoly? If the state is granting one person a monopoly, why is the state not granting everyone the same monopoly? And the answer to that is obvious. Obvious because obviously the person who is being granted the monopoly has done something unique. And what is the unique thing he has done? The unique thing is that he has invented something. Invented what? Invented something that was not invented before. So he has brought in a totally new technology. And therefore, the state is granting that monopoly. Now, coming back to what I said, it's obvious. Obvious, I'm trying to say is this, that the state has not gone mad to grant people a monopoly for a new invention, for a new technology, just because one person is claiming it. I cannot be doing that. Obviously, the monopoly is going to be granted only when that person is sufficiently able to prove that he deserves to get that monopoly. So to say I have a new technology is one thing. To prove that I have a new technology is an altogether different thing. So there are criterias that have been laid down for the scientist, the technologist, the company to prove that they deserve to get a patent. Coming to what kind of monopoly? The monopoly is this, that if you have invented something new, not heard of, not seen of before, and you want to protect it, then the state allows you to protect it through a patent. Once you get a patent, then you alone are entitled to use this technology and sell it. So only you are giving the rights to commercialize your technology and nobody else. But what is happening in all parts of the world? People see a new technology and people then rush immediately to copy that technology and produce a copycat product and then sell it in the name of the original technology. Is that so or not? Tell me. All of you. Can you give me examples of copycat products? Asking all of you.
Yes, ma'am. Yes, ma'am. We can give, ma'am.
Tell me.
Ma'am, Google, Facebook, all of the social media companies are copied by different places.
But is their product a copycat product?
Oh, you're talking about a product, a specific product.
Yeah. You give me
Then many
products.
smartphones.
Smartphones, do we have copycats in smartphones?
Yes, yes, it is
Yes,
there, ma'am.
we have fake products, right? When we say fake
Yes.
products, when we say counterfeit products, we are saying that they are a rip-off of the originals. Most often we find rip-off in the fashion industry, right?
Yes, fashion, textiles, and this
Yeah,
jewelry
textiles,
also.
so they are ripped off. Likewise, right? In the auto industry, you find that people will steal the original product and put the, for example, the three-star logo of Mercedes Benz is one of the most commonly stolen items because people love to steal that and put it on their car. So the moment they have put it on, installed it on their car, it gives an impression, oh, this is a Merc, a different looking Merc. But because that 3-star is there, the people on the street will say, okay, this is a Merc. You're not going to inquire beyond that. So the world is full of copycat products. The world is full of parallel industries, be it in watches, be it in technology, be it in whatever form you say. For example, even in films, you make a film which is an original film, and then that film gets pirated. What is the meaning of the film getting pirated? Come on. What is the meaning
It's
of
copied through digital platform, ma'am. It's copied
Yes,
through
it is
digital
copied. The
platform
original is
without paying any money to
yeah,
the producer.
absolutely. Without paying anything. So this is what happens. Then everyone starts making a copy of that technology. Everyone starts selling that technology. And finally, tragically, you get displaced from the marketplace. So slowly, as the system of patenting gained ground, people realized the great merit in patenting. So scientists, technologists, the first thing they start once they start embarking on their product is to get their product patented. However, the governments all over the world are very clear. We grant you a patent provided. The provided is that you disclose the entire invention to the government. So the grant of patent is always against the disclosure of the invention. The disclosure of the invention is very important because look, the country can grow, whichever country that is, only when the technology is brought into the public domain. So we must give you monopoly, but we can't give you a monopoly forever. So monopolies are granted for a very limited period of time. And this came to be recognized all around the world. So now all around the world, in most countries in the world, a patent is granted for a limited period of 20 years. So 20 years, you can use the invention the way you wish, but after 20 years, automatically the invention comes into the public domain. Then people are free to copy that invention and innovate on that invention. All right. So how is the patent granted? The patent is granted in India by the Controller General of Patents, Trademarks, Designs and Geographical Indications. Now also copyright has been added to it. It is granted to an inventor or his assignee for an invention for a limited period of 20 years and is valid only within India. I hope you have paid attention to what I've said. You get the patent, you can exercise the rights under that patent only in India. You cannot exercise the rights under that patent in another country. Anyone wants to ask me any question here?
Ma'am, if someone copy from
Yes.
outside that country, what should we do?
What can you do? Tell me. Think logically and tell me.
Lawsuit.
Let's say I find someone who's copied my invention in US. What should I do?
Ma'am, we can file a suit against.
Against whom?
Ma'am, against that person.
On what basis? मेरे को एक basis चाहिए ना?
जी.
Basis क्या हो?
Then again, patent has a different country also, registration also, like US, India, China, and also WTO. Then how does it come to a conclusion?
Yes, that's true. Now coming back to what we were talking about, if someone has stolen what I have made in another country, there is very little what I can do about it. I need one common law under which to book him, no? Now that person is a citizen of US and I am a citizen of India. Under which law has he stolen? He has stolen under my law. And my law is not recognized in the US. Are you understanding the problem? I can give you a parallel over here. The parallel is that the government of India is trying so hard to extradite Lalit Modi, to extradite Vijay Mallya, to extradite Nirav Modi, is trying so hard to extradite Mehul Choksi. What is the problem? Why can't they extradite? They have broken our laws, so extradite them. Extraditing is not so simple, right? Because it is my law versus the laws of the country in which they are residing. They knew very well what they were doing when they ran away. They knew that they would find protection in different geographies. So this kind of system does not work. So this is what the world realized. And just like someone just now mentioned, they then realized that the only way we can protect a person who is the owner of a technology is to allow that owner to get his technology patented in different countries. So today, when you are filing a patent in India, you can simultaneously file patents in different countries in the world. Once you have a patent in that country, you can file a suit against somebody who has copied your invention. Is that understood? Is that understood by all of you? Okay.
Yes, ma'am. Thank you, ma'am.
Yeah.
Yes, ma'am.
Now moving on to what one can do with one's inventions. One can do many things with one's inventions. For a starter, I can make my invention and just make it free for everybody who wants to use it. Because let's say I'm a philanthropist. I don't want to take anything for my invention. The other is, no, my invention, my idea, I have worked on it. Why should I make it known to all the world? So I make and I work my invention in absolute secrecy. Now, absolute secrecy as a system works only if I am working alone. All right. The moment I get workers to manufacture my invention is being shared with other people who now know what I am doing in that invention. So it's no longer such a big secret. I can tell everyone, "Arey bolega to dekh lega, arey bolega to dekh lega." But finally, somebody or the other will tell. So it's very difficult to work an invention in secrecy and to keep it a secret. Secrets are secrets until they are disclosed, and they get disclosed like it or not. All right. So Coca-Cola composition is going on as a trade secret, but people are quite knowledgeable about what the composition actually is. All right. Coming to work, the next third thing is I work the invention openly. We have also met a lot of startups and a lot of young innovators who have made the inventions but are in a great hurry to commercialize the invention. So let's say they have created a different kind of stove. a stove, and they put it out in the market and start selling that stuff until that stuff actually gets copied. जिस दिन कॉपी हुआ उनका मार्केट खत्म, और जब तक पैसा मिलता गया ठीक है, they have made a lot of money on their invention. All right, so this is very limited in to work the invention openly. The next and the last one, which is the best of all, is I don't work it openly, I don't work it secretly, but before I work it, I get a patent in my name for the invention. Once I get a patent, then I work it openly, because right now all the rights relating to that invention have been granted to me. So this is what patents are all about. There is always a critical question that are asked: should you go for trade secrets or should you go for patents? First issue is why this question? This question is because patents are very difficult and very arduous to file and to get. Patents are not, got easily. When we look at law, we say that the most complex law in the world is the patent law, right? There's so many procedures, so many stages, so many nuances to the law. That's really very difficult for everyone to say confidently, oh, I'm a master in patent law. Means it's really rare to come across such an individual. But having said that, we then come to the issue: where are the problems with granting a patent? No government is going to grant you a patent just like that. Every government wants to be sure before every patent that they grant that there was an invention that truly deserved getting that patent. You see what the problem is. Once you grant a patent, you have blocked all competition in that area for the next 20 years. So for 20 years, one particular company or one particular person alone will be allowed to work that invention. So if anyone comes close to copying that invention, they will be filed with infringement. So this is a very tricky issue. And because the governments have to grant it carefully, considering every aspect of the invention, patents take a long time to be granted, especially in India, because there is so much to examine in a patent. The patent documents are very long, 30, 40, 50 pages, describing the invention in full. All that has to be read, every letter, every full stop, every comma has to be read. So it takes a long period of time. So in India, normally you will get it between 4 to 5 years or even more. Patents are granted after 10 years. So it's difficult because the life of the patent is only 20 years. And if so much time is lost in granting the patent, the fruitful years of the patent become less. So this is one issue. So people say, chodo na, don't have to patent it, go in for trade secret. But as I already mentioned to you, trade secrets are very risky. जब तक disclosure नहीं हुआ ठीक है, but once your disclosure is made, you have lost whatever edge you had in the marketplace. Also, depending upon the sector you are in, depending upon the R&D investment that has been made on the particular invention, depending upon what is riding on that invention, depending upon what is there to lose if the invention is lost, one has to consider so many factors before one decides whether to patent it or go in for trade secrets. So if the invention is of low value or a medium low value, then probably better to go in for trade secrets. But if the invention is of high value, high degree of investments on that invention, then it is very important for the inventors to get the invention patented. Sometimes what happens is people are not able to decide what to do. So there is a third method also. And the third method is called defensive publication. You are looking at your invention, you are not able to really prove its inventive value. At the same time, you feel that it needs to be, the ideas there need to be protected. So one of the best ways is to write on that particular invention, to come out with a research paper on that invention and what it does. So what happens is, while you may have not gone in for a patent, this particular publication becomes what we call as prior art. So what is prior art? Prior art is already existing knowledge on a particular line of technology. So there is a technology and you have already disclosed that technology. So that technology becomes in the domain of known knowledges of a recent invention. So this automatically prevents anyone from seeking a patent on that particular technology. So it's like this. I am also not going in for a patent for my technology. I am also not allowing you to go in for a patent for your technology. So this is the benefit of defensive publication. Remember one thing, that trade secrets are a risky choice, given that there would be a risk of infringing future patents or a later innovative competitor, or if an innovator also decides to keep his technology a trade secret. So coming to when is a patent granted? A patent is granted for an invention when that it means a new product or process, inventive step capable of industrial application, when it is new and novel, when it has a non-obvious inventive step. So there must be a technological advance in your invention and you should be able to show that technological advance. And it should be able to show that it is of benefit to mankind, that it can be produced by an industrial process and it is of benefit to mankind. So these are the three steps before a patent is granted. This is not or novelty or inventive step or industrial applicability. No, this is novelty and inventive step and industrial applicability before a patent is granted. So basically, I'm not getting into too much detail to say that you should be able to show that there is nothing on the technology that you are making or you are manufacturing, and there is no literature available on that technology. The literature available on a particular technology is called its prior art. All right. So now, for example, people who are coming out with antiseptic ointment, turmeric antiseptic ointment, and they go to the patent office and say, we want a patent on turmeric antiseptic ointment. The patent office is going to say that you are not doing anything new. Our literature shows enough documentation of antiseptic properties of turmeric. So the prior art has been established and is shown. All right. Inventive step, as I said, the technology that you have created, that technology should not be obvious. Like, for example, if I say 2 plus 2 is 4, 4 plus 4 is 8, 8 plus 8 is 16. Therefore, if I am saying 16 plus 16 is 32, that's obvious. But if I say 16 plus 16 is 42, that's where I am inventing. That is my invention. So it should not be something that is predictable, something that is obvious to people who are in that particular field, who know. So it has to be non-obvious. So that is where you will show the technological advance. And then, as I said, it has to be of industrial use. Now, prior art search is something that we do before we embark on patenting. Like, for example, if people come to me and say, we want to patent. So I tell them, without disclosing your full invention, please give me the bare basic fundamentals of your invention. What is your invention about? I ask them. So my invention is so and so. Like for example, somebody said that my invention is to help people walk straight who are suffering from a particular disease. I'm not mentioning the name of that disease. Now, people with that disease are not able to walk straight. So this person is making an invention to improve the gait and the posture of people suffering from that disease. So once he does, or she does, explains all this to us, we look at that, we look at keywords, and we search the globe, we search the world for literature that we can find on this kind of invention. Which means we have to go into patent offices all over the world, look into their data. We have to look into all kinds of research publications, and we are able to figure out whether anything has been written on this kind of invention or not. If it has not been written, then we say your invention appears to be novel. I use the word appears. No one can conclusively say that it is novel. We will try all the best methods to say that this invention is not heard of anywhere in the world. All right. So once its novelty is proved, we then go to writing of the patent. So these are the sources of prior art, previous patent literature, books, conferences, trade and professional journals, advertising catalogs, government documents, illustrations. Right? Going back to why else we need to do prior art search. We need to do the prior art search because it also helps to clarify the position of the invention. How many close inventions are there? How many, what is the kind of knowledge that is existing with respect to this line of technology? So we come to know what is that line of technology and what are the close inventions. Is there language anywhere which says that I may be infringing someone's patent? So we look for that. And then we say, no, we will change the language of our patent so that we steer clear of any infringement. The person who wants to patent can basically assess the strength of his invention. So to understand how good or bad is your invention, we need to do a prior art search to find out the strength of your technology. All right. We come to the next thing, that is writing a patent. So as I said, the patent document is not only read by one or two persons. The patent document is read by so many people in the world. So who are the people who read the patent document? Obviously, people in your company or people who are manufacturing your invention. So all of them would be reading your patent document. To get the entire process or to understand the entire product, they would be reading the patent document. But along with that, who else will be reading? Of course, the examiners in the patent offices, whether in India or other places in the world, will be reading your patent document to understand whether you deserve a patent or not. Inventors, scientists, researchers would be reading your patent document. Most importantly, competitors would be reading your patent document to understand what is your technology and to understand what can they do in terms of next steps. How can they innovate and come out with a better technology? Product developers would be reading your patent to understand what they should not be doing so that they don't infringe your patent. All right. When the case goes to the court of law, lawyers and judges would be reading your patent. Last but not the least, when you are commercializing your patent and you are giving it on license, etc., then the licensees would be reading your patent document. So it's very important how you write your patent document. First golden rule about writing a patent document, that is disclosure of the invention. See, disclosure of the invention is at the heart of patenting. It is the essence of patenting. Patents is very simple, a trade-off. You give me this and I give you that. So you give me the invention and I give you a patent is the clear, simple key to patenting. So when this happens, they are asking the inventor to tell in precise terms and language how the invention has been made and how anyone else going forward can make that invention. So when we are writing, we have to write not only one way of making the invention, we have to write all the different ways that we know of making the invention. And along with that, we have to write the best way of making that invention. So the best mode of making the invention should be mentioned in the patent document so that, the whoever else is keen on making this invention would be finding it easy to make this invention. We say that if an invention has not been disclosed fully, the patent may not be granted, or somebody may file an opposition saying all the aspects of the invention was not disclosed and therefore this patent should not be granted or this patent should be revoked. Please remember, a patent granted can also be revoked. So the disclosure of the invention is very, very critical to writing of the patent. So when we are writing the patent, we must first understand that we have to give the complete overview of the working of the invention. That complete overview of the working of the invention is given in a document which we call as description. All right. The scope of the patent, all right, is explained, and the object of the patent is explained in the background and the object, but the claims is the one which tells is what we are essentially patenting. Let me rephrase to you. Patent claims is what we claim as an inventor. We say, let's take a thermos flask. Now the thermos flask may be having something opening at the bottom. Now that invention of a thermos flask where I keep the freezing gel in the bottom part of the flask is my invention. I'm claiming that. So I claim that only I should be allowed to make that invention and no one else in the world. That's the claim. So therefore, there is another part of the patent document, which is basically the claims. And the claims define the legal boundaries of the patent protection. That this is my territory and nobody can come into my territory. Only I am allowed to make this particular invention. So they inform the public what is allowed and what is not allowed without the permission of the patent owner. All right. So when we are talking about infringement of patents, to understand infringement of patents, it becomes important to read the claims document. So each claim may be read out separately, and we will understand from that whether a patent has been infringed or not. All right. So I'm bypassing this, coming to this. So when we are writing the complete document, it is specifications. Now specifications are of two kinds: provisional specifications and complete specification. All right. So let's say you have started on your invention, but you have not been able to finish it. At the same time, you know that there is a competitor who is working on the same invention. Just see what's happening in the world today. There is a pandemic. Most pharma companies are working on trying to produce a vaccine for COVID-19. So they are all working in the same area. Now, whoever gets patent will be the one who will laugh all the way to the bank, because they will be able to commercialize their patent. For example, in this entire COVID scenario, AstraZeneca and Oxford have been an early player. They have been able to get their vaccine patented, so they were able to license their vaccine to other countries in the world. So this is exactly what we are saying. If you know there are lots of competitors in the marketplace and you still require some time to complete your invention, then the law in most countries in the world gives you time, 12 months, to file a complete specification. In the meantime, let's say that you are in a rush to get your patent, you can file a provisional application. Provisional application, just discussing the bare minimum of your invention, and block the date. The patent is always granted from the date it has been applied on, and not from the actual date of its grant. The 20 years is counted from the date it has been filed and not from the date it has actually been granted. So these are some of the very important things that I am telling you. So remember this. So provisional is so that I can actually reach the finishing line first. If I am first to file, I'm first to finish. That is the logic. Within 12 months, complete must be filed. Complete specification must have a title, must have a description, must have claims, must have drawings, and must have abstract. I hope you have paid attention to what I have said. I've used the word must have. I did not use the word may have. So there is no compromise on this structure of the patent document, and the patent document has to follow this kind of structure when it is filed for a patent to be granted. The reason for fixed formats is because then they become easier to be read and understood by people who are reading the document. So provisional, I have just explained to you. So we file it when we have not completed or we are in the process of finalizing our invention, which is going to take few more clinical trials, or will take few more experiments, or will take few more, analysis or studies to be done before it can be conclusively completed. So till then, if I have filed it, I get a clear lead of 12 months to file my complete specification. So complete specification will contain full description of the invention and all the claims which the inventor seeks for his monopoly. All right. As I said, object is to define the boundaries of what I can do and what others cannot do with my invention. All right. So this I have already repeated to you. This has been given to us already in the earlier slide. Now we come to description. Now what do we write in the description? We define the key terms and we describe the invention first briefly. We give a summary of what the invention is all about as a quick tour of the invention. And then we give a complete description in great detail. Now, when we are giving this complete description of the invention, then you are expected to write it in the format of step 1, step 2, step 3, step 4, like that, in complete detail. Every little thing that you have actually done with the invention must be documented in the description. So there you also add your examples, illustrations, tables, graphs, diagrams, everything that went into making of the invention. We also use another term. The enablement has to be clear and concise. That anybody reading it should be able to understand what to do next. So, okay, I do this first, then I do this, then I do this, then I do this. It's written as clearly as it gets. And we have to, as I mentioned it before, again I'm repeating, we have to mention the best method of performing the invention so that finally the entire detail, when it goes out into the public domain, the public will not have any difficulty in understanding the invention. Coming to claims is our main area. Claims are basically, see, we say what you are claiming the invention. And it's not just one invention. Within an invention, there could be multiple inventions. So you are writing many claims. You don't only write one claim, you write many claims. All right. Just now, for example, we have filed a patent in which we did 20 claims. Claims actually could have gone on to 30 claims, but we decided to cap it and make it only 20 claims. So, the point is, if you go in for more claims, then the governments all over the world also charge you for extra claims. So these are some of the very interesting things that is there in the patent law. So this is telling you no trespassing for 20 years. This is mine. This is my turf. So what is claims telling you? The validity of the patent lies in its claims. So if you have to understand a patent, you have to understand, sometimes when we are reading patent documents, and we are in a rush, we bypass everything. We straight away go to the claims and see what has been claimed. Once you read the claims, you know what the invention is all about. So it's telling you that that a particular kind of technology has been claimed in the claims. All right. The main claim is the most important part because it defines essential features in broad terms. Then there are dependent claims, there are additional features, and separate claims are formed for separate features. There is something called as omnibus claims, where it is described generally and it refers to diagrams or figures. For example, an apparatus for harvesting corn, as described in the description in so and so figure, or a juice machine as shown in figure 4. So this is one way of writing claims. If you do not claim, you disclaim. This is a golden rule which has to be remembered. Now the patent claim format. The patent claim is broken up into 3 components, A plus B plus C. A is the preamble, B is the linking word, C is the main body of the claim. So preamble means identifies the category to which your invention belongs. Is it a product? Is it a process? So is it a kind of a device, or is it a composition, or is it a method? All that is written in the preamble. All right. The preamble talks about the objective of the invention and is consistent with the title of the invention. The linking word. So we then go on to the word which is going to link the preamble with the main body. So that is an open-ended phrase. So I can say that a device to make let's say tea, a device to make tea, comprising of. Now I've used the word comprising. So comprising becomes a linking word. Now when comprising becomes a linking word, the word in itself is an open-ended phrase. Comprising is an open-ended phrase which tells you that it contains so and so, but it could be more. Including is an open-ended phrase. When I say including so and so, it means this plus so and so. Whereas if I say consisting of, it means only this much and nothing more. So we have to choose the linking word very carefully and then make a whole coherent sentence, which is the main body of the claim. All right. So these are some of the keys to the claims drafting. I'll bypass this and go straight away to the example so that you understand it better. So coming to the object of the invention, let's say object of the invention is to cook rice. So I can write here an apparatus for cooking rice. An apparatus is the preamble. For cooking rice is the object of the invention. All right. Now I've not written more. I have to write more. So I have to put it with a linking word and then the main body of the claim will follow. Now look over here how the next one is written. It's an invention for cooking grains. So I write an apparatus for cooking grains. And then it's an invention for cooking vegetables also. So, and foodstuffs also. So I make it an apparatus for cooking. So it is generally for cooking all kinds of things. Similarly, there's an example, a method for extracting petrol. So I write a method for extracting petrol. Now this is a method. This is what we call as a process claim. Now the object of the invention is to extract petrol from underground sites using reformed gases. So I have to bring it in the preamble. A method for extracting petroleum from underground sites using reformed gases. Then I come to an object of the invention where the apparatus is for extracting petrol generally. So I say apparatus, methods and systems for extracting petroleum using a portable reformer. Now this one, when you see the third one, you realize this is the widest one of the lot. Linking words I already explained to you, open-ended phrase like including, characterized by, close-ended phrases like comprising, consisting, basically means nothing else. Now suppose I write with respect to a chemical compound. A chemical compound consisting of 50% A compound, 25% B compound, 25% C compound. Could I have written this in another way? Answer is yes. I could have written a chemical compound including 50% component or inclusive of so and so component. Moment I write this, then it means that this chemical compound other than component A, component B and component C would be having something else. Now the question that arises is this what you want to convey? Because then the chemical compound's nature itself will change. So we don't want to convey something which is not. Therefore, in cases of chemical compounds, it's very important to be very precise. And therefore, words like consisting of, comprising of are very, very important. This example that I have given over here, a flashlight for use with batteries comprising of a tube to hold the battery, lamp to illuminate, a holder to mounted on the tube to hold the lamp, a switch mounted on the tube, the switch being manually movable between on and off positions and connecting the batteries to the lamp when in the on position. This is the first claim. This is the first independent claim that we write, which is the broadest claim explaining the whole invention in a nutshell. Now, from this first claim, we make many other claims. So while you have created a flashlight for use with batteries, the question is, each of these components in that flashlight are also inventions which you have created. So for example, this tube is your invention. The batteries may not be your invention because they are already existing. The lamp which you are illuminating is your invention. The holder which is on which the tube is mounted is your invention. The switch is your invention. So all of these are separate claims. We say the tube of claim 1, and then we describe the tube invention. Then we say the holder of claim 1, and we describe the holder invention. And so we describe in all of them. All right. So this is another example. I'm giving you an example of dependent claim. So this is a lighting device comprising a source of energy, light source, a temperature responsive resistor, current modulating circuit, all of this. So now I say the lighting device of claim 1, wherein the pulsed current is thermally compensated. Or I say the lighting device of claim 2, wherein the duty cycle of the plant reduces if the temperature of the light source increases. The lighting device of claim 2. So you are referring to an earlier claim and making it another claim, and that's a dependent claim. So I've given over here different types of claims. We have broad claims and we have specific claims. We have independent claims and we have dependent claims. We have method claims, which are process claims, and we have use claims, which are talking basically about how a particular substance can be used. We have composition claims, where we are talking about chemical compositions. We are having biotechnology claims, software claims, and other claims, as I've already explained. We come to patent infringement, which I want to talk to you about, which is basically the area where the trouble is lying. So it's basically a tort, a theft of an idea or an invention, when one person, without the authority or permission of a patent holder, makes, manufactures or assembles a product which is an invention and which has been patented, uses a patented product or process or continues to do so, offers for sale or sells a patented product or process and implies engaging in a commercial activity thereof, imports into India any product covered by a patent for commercial exploitation, claims product or processes being challenged should have at least one claim falling within the scope of the infringed patent. All right. Now, when we are doing infringement, two documents are compared. And two documents are compared, and it has to be proved that the infringer has taken from the original document. For this class, I have documented one very interesting case that I found. And this case is Shogun's Organics Limited versus Hari Guchait. This case was decided only in 2019. Very, very interesting case. Shogun's Organics, I don't know if any of you know, but is engaged in the research, manufacture, and sale of mosquito repellents. All right. But they had come out with a patent for one of their products, and their product is D-trans-alethrin. So this is an insecticide, and it is an active ingredient that is used in all mosquito repellents. Now, when they filed the patent, they filed it under a, they filed it various claims, but basically they gave a 6-step process of making this D-trans-alethrin. But they subsequently discovered that their competitor, all right, was making this process and was marketing their product under the competitor's name. That means they were using their patented process for marketing their product. The patent that Shogun applied for was on 10th May 2007. So many things happened with this particular company. They were granted a patent on 13th November. Now, this particular competitor who actually copied this patent, before they got the patent, had already, this company called Manaxia, they already filed what is called as pre-grant opposition, challenging the grant of the patent to this company. That opposition was heard, and the patent office felt that the opposition was not correct, and they granted this patent to this Shogun on 13th November. After the patent was granted, again, Manaxia, along with somebody else, filed a post-grant opposition saying that this particular patented method is prior art. And they themselves have been manufacturing this D-alethrin by using this method right from 2007. They made all kinds of allegations. But the patent office heard the post-grant opposition and revoked Shogun's patent. Shogun then applied to the Intellectual Property Appellate Board, and the Appellate Board heard the case and restored the patent, saying no, there has been no, the patent was not a prior art, the patent was a purely novel process, and the patent has to be restored. After the patent was granted, the plaintiff conducted some investigations and found that this competitor firm was selling the competitor patented product in India by themselves and through various distributors and retailers under brands and sprays and mosquito coils, famous brands called Maxo and Mortine. So the Maxo and Mortine that were there in the marketplace were all infringing products. The plaintiff then conducted tests. They conducted tests on Maxo and found that the chemical composition of Maxo and theirs was just the same. The plaintiff then sued the defendants for using their patented process. Of course, they have won the case, and it is a lovely judgment which said that the plaintiff was entitled to permanent injunction against the defendants. That means they were entitled to restrain them, and the defendants could not bring in that product into the marketplace. The defendants were finally asked to pay the plaintiff all sales, profit, of sales, all damages and all costs were made by the defendants to pay. It was also held that just because the plaintiff has held or given the product to the registry for under the Insecticides Act does not mean that it has disclosed prior art. So this case was wonderful in understanding what can be done when a patent is infringed. So when a patent is infringed, you get injunction. That means you get the right to restrain the defendant from acting in a particular manner. You get damages and accounts of profits, which in this case, the company got from the defendants. The court asked the defendants to pay damages to Shogun and accounts of profits, all sales that they made after selling products like Mortine and Maxo, etc. And they also have the right to destroy or seize infringing goods. So these are the remedies that are there for infringement of patents. Very quickly, what is the anatomy of a patent? How does it look? A patent document. So it has cover page, it has patent drawings, it has patent specifications, which I have talked about, and patent claims. All right. This is how a cover page of a patent looks like. So all this you can see: date of application, publication date, application number in another geography, name of applicant, Tejan Pharma Limited. So all this, all the details that you want about the patent, you can immediately get it on the cover page. I take a look at the cover page and we know all the history geography of the patent. All right. I'm going to just talk in one line about patent cooperation treaty. I told you patent is only in the country of filing. I get a patent for one country. I cannot protect my invention in other countries of the world. If I need to protect my invention in other countries of the world, I have to seek patent separately. Now, if we were to go by a system of separately filing patents individually in different countries, then the process would be very tedious and very difficult, which it was until 1970, when the world realized that we need to adopt a common platform for filing one single common application. So it is a window for filing your international application. You make an application and you say that this is my patent in India and I want to file it in certain countries in the world. Then after some time, when it is ready to be published, the World Intellectual Property Organization, who manages the Patent Cooperation Treaty, lets us know that it is now time for us to enter different countries. And that's when we decide which countries we must enter. You must remember one thing: to enter all the countries or to file a patent in all the countries is a very, very tall order, very, very expensive process. And only big pharma companies can afford to do that. So generally, people who want to file their patents in other countries do so on the basis of which are the countries in which they are exporting their products. So based on that, on the countries where you're exporting the products, or countries where there is a demand for your products or your licensees are there, those are the countries you will seek a patent. So with this, I'm going to give you a snapshot of patent filing in India. I believe that others will take you through in greater detail. So this is provisional application, goes on to complete application, that is complete patent application. And then it goes to request for examination of the patent, which must be examined within 48 months. And then there is a first statement of objections, which we called as the first examination report. The examination office issues that report to us, based on which we give replies back. That is the response to the office action. Based on the response to the office action, they may call for a re-examination, or they may reject it, or it may go to grant. So this is how a patent, as I said, it is a long, arduous process, not happening quite easily, and it takes a lot of time. If you do not, in the meantime, the public are also given the right to oppose the grant of the patent. India is one of those few countries in the world where you get the option of doing an opposition before grant or an opposition after grant. So these are some of the things that you ought to remember with respect to patent filing. I also realized that this was a bit too technical for many of you, but in case there are any other questions that you have, please feel free to ask me. In conclusion, I just want all of you to sort of note something that I have always admired, which I read in a book long ago, and that is to create something from nothing in all the natural world is a human ability. Using our minds, we originate works of art, generate inventions, accumulate knowledge, and discover truths about the world we live. What sets the information age apart from prior periods in history is the price that we put on these intellectual creations. Your intellectual property. That's for you to take a call. I think I'm done with my session.
Thank you, madam. Now we can take questions, friends. You can ask questions one by one. I think Vinita wants to ask.
Madam, your PPTs were very nice, interesting.
Hello.
Yeah, Vinita, now you can unmute.
Hello.
Madam, your presentation was excellent, and I need your PPTs so that I get my innovation patented. Please provide your PPTs right now.
Dr. Vinita, you can approach Madam. I will give you Madam's email ID and she will help you out in sending your code.
Thank you so much. Sharing.
Okay, sir. Thank you.
Mute yourself. Please mute. Yeah, Arun Kumar.
Ma'am, this is
Yeah, please.
yeah, sir. Yeah, I'm Arun Kumar from Ramco Institute of Technology. Ma'am, I'm having a clarification related to PCT application.
Oh, tell me.
For example, say if I'm going to file a PCT application and I have approached, say, some 40 countries. So a country X have granted me the patent.
Yeah.
But while verifying for the prior art state, a country Y have rejected my patent.
Correct.
Will there be a chance for me, the country X, by stating that Y have rejected my patent, so that I'm also going to revoke a patent? Is there any possibility for it?
Sorry, I didn't get this last part. What?
Actually, my patent has been granted in country X.
Yeah, I got it.
Yeah.
In another country, you did not get it because they found prior art, right?
Yes, exactly.
And then.
Now the question is what the question is that the country which have already granted me the patent, by referring to the country which rejected my patent, will there be a chance the country which already granted me will be revoking my patent?
No, not at all. Not at all. Not at all. This is territorial.
Fine.
This is territorial. They have gone by their yardsticks. They have gone by their law. That's what I told in the beginning. No, my law is different from your law, is different from all the laws in the world. When in a country, I have to follow only that law of the country. So this is one interesting thing that you have brought up. And that's a question that if I get a patent in one country, does it mean that I will get a patent in all the countries? Answer is no. I may get a patent in India, but I still may not get a patent in US. But just because my patent is rejected in US does not mean England can reject my patent on the grounds that it has been rejected in US.
Yeah, okay, fine. Thank you.
Okay, thanks.
Any more questions, friends? Is there anyone wants to ask question? Okay. Thank you very much, madam. I think you took extra time, but we actually forgot count on time because it was so interesting.
Yeah.
It was explaining, everything like from, from all the dimensions, from patent filing to the treaties, to the infringement, to trademarks, copyrights. You have touched upon almost everything, but more specifically about the patent documentation, the drafting and all you have shown in the last slides, how it looks like. So it was a very, very informative and very, very interesting. It's a very good session. So we thank you very much on behalf of all the participants from my institute and from the organizing team of the institute. I am thankful to you. Thank you very much. We will see you in coming days for other lectures. Thank you
so much, Dr. Rao. Thank you for giving me this opportunity to speak to your delegates. Thank you very much. It's a pleasure.
Yeah, thank you, friends. We'll meet tomorrow morning session. Thank you. Have a nice evening to you all.
Good evening to you.
Thank you, sir.